afternoon to all the viewers and the student of Parul Institute of Law, Parul University, Vadodara, Gujarat. First of all, I warm welcome our eminent speaker, Mr. Vikramjit Banerjee, who is the Additional Solicitor General of India at Honorable Supreme Court. So, on the topic of Indian heritage and ethos in the constitutional scheme. So this is the very interesting topic, and our student have chosen this topic. So we have proposed sir for this topic, and sir has accepted. So I warm welcome. I just have an introduction that sir is also one of the good student from the National Law University Bangalore, and he has deal with lots of big matters at Honorable Supreme Court as well as Delhi High Courts. So I will not take more time. I will just warm welcome, sir. I will just let me introduce about the Parul University. Parul University is a recognized university at Vadodara, Gujarat, and we are the sirs after GNLU. We are the second leading in university in the law concern in Gujarat, sir. Sir, our dean sir has also joined. So I tell Dr. Akhil Sayyed sir to warm welcome our eminent speaker, Mr. Vikramjit Banerjee, sir. Dr. Akhil Sayyed sir.
Namaskar, Banerjee sir.
Namaskar.
It's our great pleasure. Sorry for being a little late. I had another meeting.
That's okay, I understand.
Yeah. It's our great pleasure that your good self has spared your valuable time with us. And the topic also is really wonderful and it touches to my heart also. And I am always thankful to Dr. Rajesh for choosing such a topic, and that too with the most appropriate person who can give the justice to this particular topic. So we are very much delighted, sir, for your kindness to accept our invitation. And I further extend my invitation that once the pandemic has been over, we request you to kindly do visit to our university. It's a big university in the western part of India. We do have 150-acre piece of land and this green lush campuses, and our university caters almost all the branches of faculty, including law faculty. We have engineering, medical. Rather, we do have 700-bedded hospital also in the campus. So it's a really would be a nice experience for your yourself also. Not taking much time, I once again welcome you. Thank you, sir. Thank you for coming.
Thank you, sir.
Now I will handing the session to one of the senior most lawyer of the Honorable Supreme Court, Mr. Vikramjit Banerjee, sir. Sir, this session is handing to you, sir.
Thank you, Rajesh. Thank you, Akhil sir. Thank you so much for inviting me to speak in this program. It's not only a pleasure, but it's also a great honor to speak and to talk on a subject which is in some ways very dear to me. And thank you again. And that being said, just a small correction. I am not one of the senior most lawyers of the Supreme Court. I'm a young lawyer, and I think I'm learning a lot still.
Sorry, sir. Sorry.
No. I'm just saying that there are much better, bigger, and much better lawyers than me. In the context of things, I know very little, and I have no such delusions of grandeur. But be that as it may, coming back to the topic, I think this is a wonderful topic, and I think that it requires to be discussed, and it's very important that going forward from here, and this needs to be a topic of discussion largely across on various different conceptions of law in every legal subject, because we know, because of two things before I start my talk, I'll contextualize that, because we know India and its civilizational understanding as well as its social understanding is extremely different than from, for the want of a better word, the West. The structure of the law that we practice, that we apply, the language of the law that we apply is undoubtedly Western. Let's not be any delusions about that. But the problems which we face day to day and which the law tries to solve are unique in Indian. This has led to a number of problems. the biggest problem is that one is the problem of translation, which is basically inculcating a rule of law means that the people understand what the law is. The biggest problem in India is because the law is in many ways it's so disjuncted from the people, the language of the people. So there is a difference. There is a large difference in what people conceive justice and law and what is there on statute books, which has led to this, increasing gap between the people and the law, which is manifested in the courts, which is manifested in people not having great confidence in courts. Irrespective of whatever people will tell you, everybody knows that you go 200 miles out of any big city in India, you will see that the panchayats and social solutions in villages are more relevant to people's lives than the courts themselves. And this happens after even maybe 300 years, nearly 300 years of the law being first applied in this country, which goes to show that people still prefer law which is close to them, a justice system which they identify with, and they keep away from the court. That is a huge problem going forward. I think this is not a new thing which I'm speaking about. Anyone who has read Mahatma Gandhiji's Hind Swaraj knows that he flag marked this question. And there have been numerous other people, not only Mahatma Gandhiji, there are a lot of other people who flagged this question. This entire question is law being greatly removed from the common life of the people because of the nature of the institution. One of the ways in which I think that we should address this going forward, because we can't get rid of the existing westernized legal structure that we have, and I can suggest that, the easiest sort of way to say is get rid of it completely. But I don't think that is possible. I think that a better way is to interpret the law in the Indian context, rely on Indian conceptions of justice, rely on Indian conceptions of law while interpreting the law. In many ways, I would think that the best possible solution to having an Indian conception of justice is to indigenize the legal interpretation of the law. Now, let's come back to the topic as we were discussing. The topic is, Indian Constitution and interpreted in terms of the traditional and Indian legal ethos. The first question, there are two parts of it. First question is, what is the Indian Constitution? Of course, we know that there is a text of the written Constitution. It has so many articles. It has a preamble, a fundamental rights chapter. It has division between legislative, judiciary, it has DPSPs, and so on and so forth. But the question which I want to ask you is a deeper question. Is it only the written Constitution? Because, there are constitutions in the world which are unwritten. And an unwritten constitution relies on conventions, on immunities, on privileges, which are not written. Any constitution that we have today, including the Indian Constitution, which is substantially written, there is also a large part of it which is unwritten, which we sort of assume. The fact that we hold the judiciary at a higher pedestal is not written in the Constitution. It is something which we assume. There are a large number of conventions which is assumed, but the fact that the president was bound to listen to the decision of the cabinet was an assumption till it was put into the Constitution at a subsequent point of time. So there is, even today, I think, for the want of a better word, this entire conception of something which we know today is the concept of reservation as we practice it, of caste is class, is not written in the Constitution. This is something which has come from judicial pronouncement, which is unwritten in many ways into the Constitution. So we assume in the way we govern a part of the Constitution which is unwritten as well. So not only do we need to have, not only when we talk about the Constitution, and it's extremely important, is not only do we need to understand that it's a written Constitution that we have, we also have to understand the conventions, the privileges, the immunities, which are sort of understanding which goes underneath the Constitution. Because Constitution is, what is the Constitution? Constitution is the framework on which a country is governed. And not every part of that framework is explicit in the written text of the Constitution which we promulgated. So for us to have a holistic judgment of what sort of a Constitution we talk about, it's important that we have, we understand it's not only the written text that we are talking about, but also the unwritten part. The next question, next proposition of the entire thing which we are discussing is a question which, I was thinking maybe 15 days back, and when I was like really applying myself to this question, is what is Indian tradition? We know what Indian tradition is, but what is the Indian tradition in context of interpreting the law? This is not an easy question to answer. Anybody who tells you it's an easy question to answer, would be wrong. The very fact that even after 70 years, one of the reasons why the judiciary has stopped short of applying Indian traditional conceptions is because they could not agree as to what were those Indian traditions which they should rely on. I'll give you an example. I'll illustrate it so that you get a better understanding. An easy text to refer to, possibly would be relying on maybe the Dharma Shastra. And I'm saying this, the reason why this is important is what we term as Manusmriti is something which has been conceived of as the basis of Indian society for a very long period of time. And not only Indian society, it is wherever India has gone. So you go to Burma today, they have a version of Manusmriti. You go to Sri Lanka today, you have a version of Manusmriti. You go to Thailand, you have a version of that. Laos, Vietnam, wherever Indian civilization or understandings of Indian civilization is gone, you have the two great texts which talk about justice, Ramayana and Mahabharata, and you have the conception of law, which was Manusmriti, which was taken. If it was in Buddhist countries, they have a different take on it. They have improvisations of it, just like people have an improvisation on Ramayana and Mahabharata. But that is the basic understanding of what law is. But Manusmriti has problems. And this is a question which haunts the interpretation of Manusmriti. One is what you do with the hierarchy of caste, which I think is the most incredible and most important question when we sort of try to implement Dharma Shastra. What do you think about the role of women when you talk about Dharma Shastra and trying to implement Dharma Shastra? But this is a question which I have always faced. But I think, going forward, what we need to understand is this, that even if you take a text like the Magna Carta, or even the American Declaration of Independence, or the American Constitution, everything, or even the French Constitution, which was first framed, everything is a product of its time. If you look at the Magna Carta, which is supposedly the great basis of emancipation in Western law, you will know that the Magna Carta treats lords and serfs extremely differently. The Magna Carta is no doubt sexist, it is feudal, it is violent, it has a lot of problems. But it's not that you rely on the entire text of the Magna Carta. And this is where I think Swami Vivekananda had a very interesting take, where he said that your past is important, but you have to test everything as to whether it's reasonable now. So I think in the context of the modern state that we have and of the demand of the times, we will have to take inspiration from what is good, what is acceptable, and what needs to be discarded. And let us not be under any illusion that there are things which should not be discarded from this text. But there are things which can be borrowed, which we can rely on, like from Magna Carta. Everybody talks about Magna Carta being the basis of of Western civilization or common law. But there have been large parts of Magna Carta which are horrendous, which are quite, absolutely feudal. No one talks about those provisions. Everybody talks about the emancipatory provisions of the Magna Carta. Similarly, we may have to go for a similar treatment. Another is the Arthashastra, which we can rely on, which I think of Kautilya, which is an interesting take on of governance, another text which we can rely on. We can also talk about something like the pillar edicts of Maharaja Ashoka. And again, of course, if you look at all the edicts together, we go by impressions. There are certain provisions of that which we may be a little reluctant to apply even today, irrespective of, the people in shorthand say Dharma Shastra is bad, is regressive, and edicts of Ashoka is progressive. But if you look at all of them, every one of them is a product of its times. So every one will have, parts of it which may not be rational to us, and rightly so, because times change. They were of an older time, ancient time, 1,000, 2,000 years back. So things have changed. We have to take inspiration of what is good, what is valid during our time, and take inspiration of good from our tradition. The reason why tradition is because it's old and it's something which we want to be inspired by today. Not everything in tradition is good. There were horrible things in every tradition, anywhere in the world, and that has gone. And rightly so. Then there are these wonderful, two incredibly important texts, which is the sort of underlying understanding of Indian civilization as we know it, and wherever Indian civilization has gone across the board, is Mahabharata and Ramayana. I don't know how many of you know that when the ICS, Indian Civil Service, people who used to go to the Indian Civil Service were taught at Ely College in Britain before they were sent off to India to administer the country. They were told that you have to read two texts, Indian texts, and one is the Mahabharata and the other is Ramayana. They would say, if you don't understand, and they didn't read it from a religious point of view. I am sure that the British civil servants who came from Britain to rule India did not read it from a religious point of view. I can assure you, most of them were strongly believing Christians who believed in many ways the importance of Christianity. Not all of them, but a lot of them believed in the importance of Christianity in civilization of the world, and they thought they were civilizing India in that respect. But they understood very clearly that, and they were told that if you don't understand the conceptions of Mahabharata and Ramayana, then you don't understand India. You cannot understand India. And this is not only in India, this is across the board, till Southeast Asia, wherever there is Indian influence, because Ramayana, Mahabharata are that important. And they're important as conceptions of justice. They are important as your conception of how you solve your dharma, your dilemma of your importance of how justice is delivered. What is an ideal Rajadharma? What is an ideal king? These are extremely important. I'll give you another example. The present president of Indonesia, Jokowi, was asked this question as to which great superhero would you want to be. They thought he was going to refer to some Marvel superhero. Interestingly, he said the person whom, and Indonesia's composition is 90% an Islamic state. And Jokowi said that I would like to be Sri Krishna. So people was, the interviewer, who's an American, was like, it's there on YouTube, was very surprised. And he said, why do you want to be Sri Krishna? He said, because Sri Krishna had wisdom, he spoke softly, and in the end, he also carried Sudarshan Chakra. So that if need to be, he could exercise, punishment as well. So he said, that is what that is my superhero. So, these are conceptions of which we have to rely on. These are texts which we have to rely on. The other is an interesting text which I was reading a few days back, is Shukraniti, which again is a very interesting text and, something which we could all look at, because it talks about governance, which is as good and as interesting as the Arthashastra. In Mahabharata, especially all of us know that the Shanti Parva is extremely important. In Shanti Parva, there is how to administer a state, what sort of governance has to be also been greatly discussed. Ramayana is the entire conception of an ideal king, which is like across the board. During that part is one part of it. The second part is we also have to, it has to be acknowledged that the last major state which existed in India before the coming of the British was the Mughal Empire. And I think in a great way, I think one of the greatest fundamental documents which are not studied too much and which needs to be studied is the Aini-Akbari. And Aini-Akbari, was formulated during the time of Akbar, which was the governance structure of the entire Mughal Empire which existed, was formulated by Raja Kodarmal, who was the, under the aegis of Akbar's reign, and this stayed, the entire system which existed, justice system, governance system which existed at the time of, till the time the British came. And that's an interesting thing which we should also, because there are conceptions of governance, how the country is to be governed. I think the first sort of complete survey, if anyone looks at, in the recent past, is not the British survey, but which existed in the Aini-Akbari. And Raja Kodarmal did a fantastic, incredible job of doing this process. And I think in Britain, what they consider the first complete census was the Doomsday Book. We had it in the Aini-Akbari at least. So we need to go into all this. We need to go into some of the fundamental texts which were which could be the basis of governance at different points of time. There were numerous other discussions of justice. And then coming to the British period, I think, definitely one of the important documents is the 1858 declaration by Queen Victoria. When Queen Victoria took over India from East India Company, there was a very detailed declaration. Now, all of you wouldn't have heard that. Most of you wouldn't even know, but I would suggest any one of you who's interested in constitutional law to read that declaration. And if you read that declaration, you will know even today how much of Indian constitutional law actually is based on those principles which were encapsulated in 1858 proclamation. You may say that it's not acceptable. All this was formulated by us in 1950. But anyone who studies the Constitution realizes that that's not so. Because in effect, all of us again, and I've always stressed this, anyone who sort of talks about the Constitution should realize this, that the structure of the Constitution which we have today is based on effectively two Government of India Acts. There were a large number of Government of India Acts, but majorly today the structure that we have is based on the 1919 Government of India Act and the 1935 Government of India Act. Completely the Imperial Council, the Legislative Council, the conception of reservation, the concept of you name it, the concept of a separate, the importance given to the civil service, the protection given to the civil service, the conceptions of equality, the conception, everything was incorporated in the Government of India Act. I think in 1950, what we did add, the governance structure remained the same, including the sort of distribution of power between the center and the federations and the federal states, which existed during the Government of India Act. The only major structure that we sort of added in 1950 is the Fundamental Rights Chapter and the Directive Principles of State Policy. And then subsequently, maybe the preamble and the fundamental duties. Now, these are the four main chapters which we added. The rest of it, in many ways, and a comparison will tell you, is largely based on the 1935 Government of India Act. So when you talk about tradition, using tradition to contextualize reading of the Constitution, it's extremely important that we understand constitutional history of India. We don't do that. The shortcut method, and this is something which is to be said, the shortcut method has been to read the text of the Constitution as it is, which I think is because people couldn't arrive at, or people couldn't conclude what is the tradition which people should rely on. And because we've tended to interpret the Constitution in an American way, whereby we sort of take the Constitution as a fundamental document of the formulation of the Indian state. I would only say this, that's not true. Because unlike America, United States of America, we did not start, the state or the nation did not start when the Constitution started. Possibly, more like any other history, possibly like British history, our nation predated the formulation of the Constitution as we know it. And the Constitution as we have, the constitutional text as we have today, is one of the methods of governing the country in a series of methods going back 2,000 years. And we have to see it in that context. The British see their constitutional law in that context. That is why the British still today don't have a written constitution. They treat whatever constitutional law they have as one amongst various different methods of governing the country which they've always had. And I said this in another talk. This seems to have been the understanding even 10 years after the formulation and promulgation of the Constitution. But over a period of time, now we treat the Constitution as almost as if the Constitution is cast in stone. It is a holy book. The Constitution, according to me, is a very important law. No doubt it's a very important law, but it is one amongst a large number of methods of governing the country which has happened before. And we have to read it in that context. So the interpretation of the Constitution that we have today has to come out of its culture, of its history, of its traditional ethos. Now, coming back to the 4 portions which were added by the Constitution, and I would just flag mark this for you so that's to rush before to finish off, is one is fundamental rights. These are which have been added in 1950. Now, anybody who knows our fundamental rights, where we formulated our fundamental rights, is this. If you look at our conception of right to freedom, our Constitution is unique because our constitutions believe in restricted freedom. Unlike the American Constitution, which believes that you have unrestricted freedom, you have a freedom of speech which is unlimited, we have from the day go have said that you do not have a right to offend anyone. We've incorporated. That's a very uniquely Indian thing to do. Because historically, if you even go to Kautilya, Kautilya says that you should speak only sweet words. Say the truth which you have to say, but you have to say it sweetly. So we have always, even the framing of our freedom of speech expression, have always been subject to restrictions because we realize that we live in a very sensitive society with different sensitivities. And as a result, the conception of fundamental freedoms that we have has been Indianized in that context. Second is the conception of right to equality. Now, we have seen the right to equality. We have seen how the right to equality has now taken shape. To the extent now, effectively, the Supreme Court has, after Indra Sawhney, has basically talked about caste is class, which is in right to equality, which says that you have to treat similarly, dissimilar, differently. And it says in 1516 you have to say that you can make special reservation or special provision for people of a different class. Now, class, as we all know, is a Western European economic method of stratification of society, of dividing society. But in India, the truth was different. So the Supreme Court actually had to, and when facing the reality of India, had to actually say caste is class. in Rasayan. So class may not be only class, it would also have to include caste as a factor, which effectively meant that whatever way you interpreted, whatever way you may have framed the Constitution, when you had to actually apply the Constitution and make it constitutional law, a living constitutional law, you had to take into context Indian civilizational understandings of conceptions of equality. 3, your conception of right to life. You have a very plain, simple right to life in the text context of the Constitution. But the Supreme Court then, in a series of judgments, expanded the right to life to mean not mere animal existence, means to right to have a full life, right to have a life in all its respects, which is a very Indian thing to do, because I don't think anywhere in any constitution in the world right to life has been interpreted to mean all sorts of things, right to lead a good life, almost everything you can include in the right to life. This is a very unique interpretation, and I would say a very Indian interpretation of what life means as a person to exist. Because when you talk in America, your right to life is, of what do they say, of justice, of equality and freedom and pursuit of happiness. In India, right to life means a full life. And this is what the court has interpreted it to be. Then the conception of right to religion, which is part of the Constitution. I think India is the only constitution in the world which has something like Article 26, which gives different sections of within a religion the right to have their own practices. Because in India, we know that not every religion has uniform practice. There are different groups within religions who have practiced differently. Then is the entire conception of right to judicial remedy. Right to judicial remedy, again, we have a unique right to judicial remedy, which gives you a fundamental right to judicial remedy, which allows you to go to court to implement that right to judicial remedy, like the American Constitution, but also incorporates high prerogative writs, which are how England approaches judicial remedy. Now, most interestingly, the Supreme Court has widened that to even allow people to write letter petitions. This is unique, doesn't exist anywhere else in the world. The reason why it doesn't exist anywhere in the world is because our conception of justice has always meant, throughout history, throughout tradition, throughout culture, for 2,000 years, the right of a common person to approach those giving justice directly. We don't think that merely because the letter of the law is satisfied, so therefore justice is satisfied. Because our conception of law comes from the conception of dharma, which is you have to, and I'll come back to that in the end, which is that dispensation of justice, which is holistic, which encapsulates everything. So it's merely whether you legally win the case or you legally lose the case is not enough, but it has to be in many ways a holistic solution, and the right to approach those making decisions independently. You look at Manusmriti, you look at Ain Akbari, you look at everyone across the board. It's always been the right to approach. In Mughal times, a right to approach the king directly for justice. In Mughal times, if you remember, there used to be this golden, the famous golden chain hanging outside Jahangir's, window in the Red Fort, and people would ring it in the middle of the night if they wanted justice. So having justice open to all has been a fundamental nature of Indian judiciary, of Indian justice system. And the judiciary has to actually, as I said, change. And that's what I said right in the beginning. Constitutional law is not merely what is there in the Constitution, but what is read into the Constitution. So Indian judiciary in so many ways, into equality, right to life, right to judicial remedy, has to actually, while addressing Indian problems, bring into Indian conceptions of law, of justice, while interpreting Indian Constitution. The other, of course, we all know, is directive principles of state policy. Directive principles of state policy, there are a large number of them. I won't go into great detail. One is, of course, one of, I think, Article 39, which says that wealth should be distributed so it should serve the common good. And the same provision, it says that, so there should not be monopoly in the means of wealth and means of production. So one part is Marxist, but the other is deeply Indian, which is almost like what Mahatma Gandhi said, that wealth should be distributed so as to serve. That's again very Indian conception of Indian law. We also know 39A, we should have a legal system which promotes justice. This, I think, is unique. I don't think that there is any other provision like that in any other constitution of the world. States shall organize, then we know Article 40 says, of the DPSP says, states shall organize village panchayats. 43 says promote cottage industries. 48 says effectively that famous provision which says, you should ensure that milk cows are protected and there should not be, there should be protection of cattle. 48A says that there should be protection of forests and the environment. So in many ways, the conceptions of governance and directive principle state, which is the fundamental principles on which governance is to be based in this country, or for the want of a better word, as in the old terminology of the world, or what should be Raj Dharma, which would be DPSP, even if it was unimplementable, because it is the king who would, by his diktat, govern, but the Raj Dharma was the broad framework under which the king was expected to function, would be something like the DPSPs. And the DPSPs are very clear and oriented towards, this inculcating a society which is deeply, in many ways, inspired from Indian tradition and culture. The other is, of course, a new edition, which was, though inspired in socialist origins, but also has deep roots in Indian thinking, is the entire conception of fundamental duties, which is like your personal obligation, your dharma, or what you are supposed to do, the obligations which you have, to make a good society, to make a holistic society, to make a living society. And in conclusion, I would say this, that, we all read the preamble, which we sort of take as a tool to interpret the Constitution. Different constitutions have different things which are its keystones. And you can read their preambles to understand what its keystones are. I think the keystone of British constitutional law is parliamentary sovereignty, importance, supremacy, because there's been a huge historical fight to establish that parliamentary supremacy. King and parliamentary supremacy. In America, I think it's freedom. In France, it is, in many ways, it's equality. Everybody should be treated equally. There should be strictly. In India, if you read the preamble, and which I think is a tool to interpret the Constitution, it continuously says that we should ensure social, economic, political justice. The word justice is repeated a number of times in the preamble. I would say the cornerstone of Indian Constitution is justice. And the reason why, there is a deeper reason, this is, in saying this I will conclude, the reason why justice is such an important cornerstone of the Indian Constitution is because at the very end, if you want an English equivalent of the legal conception of the term dharma, the only constitutional equivalent that you can have of the word dharma is justice. So, even when the Constitution is interpreted, the basic tenet which underlies the Constitution is dharma, through the English term justice, because that's the constitutional equivalent which you can have in English. And that is something which we should all keep in mind going forward. And I think in the future, saying this I will end, if we have to have a constitution which will last for 1,000 years, we have to rely on the wisdom of 2,000 years from where we came, or 3,000 years, or 4,000 years, or 5,000 years from where we've come. and to be inspired to go forward. And we should also remember, and I said right at the beginning, not everything in our tradition was good. Not everything in our tradition is valid today. But in the end, it is our tradition, our history, which makes us who we are. And we should be proud of that. Thank you very much.
Sir, it was a really very fantastic session by you, sir. You have elaborated from starting from Magna Carta to the basic concept. You have incorporated with the preamble, then you have incorporated with the article right to equality, right to life. So, sir, we have certain questions from our students. The one of the LLM students want to ask that how you correlate these the justice in correlation with the Magna Carta in the Indian
Okay,
context.
I'll answer it. I think Magna Carta is based on different principles. Is a product of its own history. As I said, the entire conception of English law, English constitutional law, is the continuous conflict between power of the king and the power of what came subsequently to be the parliament. So parliament is not an overnight institution as we see it today. It came over a period of time. Magna Carta was the first time, and that's why it's known all over the world, is when the king's absolute power was checked. All the great nobles, not common people, got together and they arrived at this compact with the king saying that you shall not violate 1, 2, 3, 4, 5, 6, 7, 8 of our rights. All of us know also that within 3 years after the formation of the Magna Carta, the king recused himself from the Magna Carta, saying, I don't believe a word of it, and he gave up the Magna Carta. And then subsequently, after a large number of struggles, it was again brought back. But that's a separate history. In India, the conception of justice, as I say, justice is something, the way we know it, has not been too much a part of English law. English law believes in equity. Justice is much more holistic understanding of the term. As I said, the approximate conception is dharma, which means that the word in Mahabharata, which they say dharma is shuksh, is very subtle. You understand what is dharma, you understand what is justice, but it's very difficult to explain as a concept of what is justice to everybody else. Now, it is not in Britain, in many ways, common law is the letter of the law. So if you win in a legal dispute, you are supposed to get justice. And equity is something which, if you're a weak person, so therefore the king does, or whatever, the person who deals out justice gives something to you so that you get some sort of equity. But the conception of justice in a holistic entity which we have today is, I would say, is different in different countries. In India, what we have today approximately is dharma.
Sir, one more question from last. This is the last question, sir. Sir, how our dharma will be going to be elaborated in the current scenario in the legal concept? It means the question of the student is how this dharma is correlated with the justice.
No, I think okay. See, that's what I am saying. See, if you read, for example, I'll give you illustrate it by an example. If you read the Dharma Shastra, or if you read Ashoka's Pillar Edicts, both of them which deal with how to, what is dharma. They both deal with conceptions of dharma. They set out certain principles, of one's obligation towards society, one's obligations towards other beings, the obligations of a good king, how they should govern the country. These are all set out in these two. Some of which may not fit in the times today, but some of them may. And I think in any sort of dispensation of justice, when the courts implement the law, as we see in the Constitution, And we have seen that they have relied on Indian conceptions, as I said, in interpreting fundamental rights. But they have not cited Indian sources. Because according to them, they can't decide which source. They know the solution is, is that. So when they know equality, they know in India, mere economic equality does not work and they have to address the conception of caste. They know that. In India, they know that Article 21, right to life, is not mere life, but it is more than life. They know that, but they can't sort of put their finger onto which source they want to get these ideas from. And they've largely relied on Western sources to justify that. I asked a great professor of Indian laws, whom I had studied with in Britain. I asked him, why do you think that this is so? Why do the Indian judiciary, why? And I can name a number of things, including your conception of secularism, which the Supreme Court says it's Sarva Dharma Samabhav. Sarva Dharma Samabhav, according to me, comes straight out of Upanishad. Now, the Indian Supreme Court knows that secularism in Indian means Sarva Dharma Samabhav.
Yes, sir.
But the reason why it does not want to acknowledge a source is because it thinks that acknowledging a source would mean that it would seem almost regressive.
Yes, sir. Yes, sir.
I am saying that going forward, to indigenize Indian conceptions of law, we have to stop relying on Western sources. Though the solutions which the Indian judiciary takes, and I say it today, is also Indianizing the law. But it has to stop acknowledging and reciting Western sources and rely more on Indian sources of constitutional law.
So thank you very much, sir. It was very fantastic session, and our student have elaborated. There are certain questions, sir, I will put on your mail. Yes. So that because I can understand your timing. So, sir, I will send you a mail of 10 questions, because there are lists of 10 questions. So I will mail that all question from LLM students. So, sir, kindly reply on that, sir. It is my humble request.
I'm sorry I took so much time, but I got...
No, sir. It was very fantastic, sir. It was really, we have enjoyed, and you have elaborated in a very conceptual manner. So it was really a fantastic session. And on the behalf of Parul Institute of Law, sir, I'm thankful to you for giving a precious time to our university. And I'm also thankful to the Brijesh Kubhani, sir, who has given a wonderful live coverage on the Facebook. So thanks a lot, Brijesh, sir, also. So thanks a lot to sir. And we are closing this session, sir. Thanks a lot, sir. Okay, sir. Jitin, sir, we are closing. Okay, sir. Okay, sir.